Good morning, this is your Kelso Report for Monday, November 7th, and I'm your host, Clark Kelso. Police officers have one of the most difficult jobs because they must make split-second decisions that can have life or death consequences, both for themselves and for others. In recognition of the challenges of the job, police officers are protected from damages liability by a qualified immunity. Under the qualified immunity, officers can be held liable only if the officer's conduct violates a constitutional right, and that right was clearly established at the time of the alleged misconduct. When the constitutional claim is that an officer has used excessive force, the standard is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them. The Supreme Court has noted that the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make those split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. Accordingly, reasonableness must be judged from the perspective of a reasonable officer on the scene, rather than with 20/20 vision of hindsight. Well, in Glen versus Washington County, the Ninth Circuit considered an appeal from a district court judgment granting summary judgment to two officers who had been sued for wrongful death in a violation of the Fourth Amendment after shooting and killing a young man at a residence where they were called to respond to a 911 call, indicating that the caller's son was heavily intoxicated, was out of control, and was threatening to kill himself with a pocket knife. When the officers arrived on the scene, they found the decedent standing near the garage along with some other family members nearby. The decedent was not at that time in a physical altercation with anyone, nor was he threatening anyone with the pocket knife or in any other way, and no one was trying to get away from him. The two officers, nevertheless, drew their weapons and ordered the family members away from the decedent in order the decedent to drop the pocket knife, telling him to drop the effing knife or you're going to die. A third officer arrived who had a beanbag shotgun with him. The two other officers ordered the newly arrived officer to beanbag the decedent. And when he shot the first couple of beanbag rounds, the decedent looked shocked, dropped his hands down from his neck, and began to move away, stumbling from the beanbag fire toward the alcove between the house and the garage, which was the most obvious line of retreat from the beanbag fire. At that moment, the other two officers opened fire, ostensibly because of a concern that he might go back into the house and harm someone in the house. They fired 11 shots, 8 of which struck the decedent in the back, chest, stomach, shoulder, and legs. The decedent bled out on the driveway. An expert retained by the plaintiffs, a former chief of police of a Washington City, with a law enforcement career spanning more than 50 years, was prepared to testify that the defendants escalated what was a static and easily resolvable situation into an unnecessary and avoidable shooting. The Ninth Circuit panel acknowledged that a rational jury could find in favor of the defendants because of their alleged concern for the safety of the people in the house. However, the court noted that the jury could also reasonably conclude that the officers unnecessarily used excessive deadly force in circumstances where no one was being threatened. The only reason it might have seemed the decedent was moving was because of the officer's own excessive use of beanbag rounds, and the circumstances objectively called for a radically different approach to controlling the decedent. In these circumstances, the Ninth Circuit held it was error for the district court to grant summary judgment for the officers. According to the Ninth Circuit, the facts were extreme enough to warrant sending the case to a jury. The court remanded the case for further proceedings. Now we have 3 one-liners today. Our first is in the area of the ex post facto clause. In re F statute, the 3rd District rejected an ex post facto challenge to the 2010 amendment of Section 2933.6 of the Penal Code. The amendment makes prison gang members who are placed in an administrative segregation unit upon validation as gang members ineligible to earn sentence reduction conduct credits during such placement. Because the petitioner continued to be an active member of a prison gang after the effective date of the amendment, the court held that the amendment was not being applied to the petitioner retrospectively, and therefore the ex post facto clause was clearly not violated. Our second case involves search and seizure. In People v. Evans, the 2nd District held that the Fourth Amendment was violated when police searched a vehicle after a traffic stop, when the driver had already been forcibly removed from the vehicle and was lying on the ground after having been tased and pepper sprayed. He was arrested for interfering with a police investigation. An automobile search incident to a recent occupant's arrest is constitutional if the arrestee is within reaching distance of the vehicle during the search, or if the police have reason to believe that the vehicle contains evidence relevant to the crime of arrest. Neither of those conditions was met in this case. He was on the ground, couldn't reach the car. The search had nothing to do with the reason for his arrest. So the warrantless search of the car in this case was unconstitutional, and the plastic bags they found, therefore, in the car should have been excluded. The plastic bags, incidentally, ultimately led to a subsequent search where they did find cocaine in the car. All of the evidence was excluded. Next, in the area of torts and the collateral source rule. In Sanchez v. Strickland, the 5th District held that when a medical provider has rendered medical services to a plaintiff, issued a bill for those services, and then subsequently written off a portion of the bill gratuitously, the amount written off constitutes a benefit that may be recovered by the plaintiff under the collateral source rule. According to the court, application of the collateral source rule in this context furthers the state's interest in promoting charitable contributions. And that's it for today's Kelso Report. Have a great day in the law.